Welcome and thank you for joining me. My name is Fred Long. I am a Pennsylvania estate planning attorney. And in this episode, we're going to talk about the very basics of estate planning, an introduction to the basic estate planning documents that you would talk about if you would go meet with an attorney and start the process of estate planning. There are two very critical components of any estate plan, and they are number one, planning for incapacity, and number two, planning for death. So the process involves making decisions about, under those circumstances, how you would want for your property to be managed and by whom. So in this episode, we're going to talk about the very basics. The foundation of any estate plan often includes documents like a will, a living will, powers of attorney, perhaps a trust, and we'll break down each of those documents in turn, starting with number one, which is probably the most commonly known and most understood, is the will. A will is a formal legal document that addresses how a person's assets and property will be distributed upon their death. An executor is named to gather assets, to pay any debts, to pay any final bills, and to pay taxes, and then to distribute any remaining assets according to the terms within the will. If you have minor children, a will is also the place where you would name a legal guardian, somebody to step in and manage the day-to-day decisions on behalf of your child until they would reach the age of majority, which is often the age of 18 in Pennsylvania. It is, and I think it probably is in most other states, although there may be states where 21 is the age of majority. You'll just want to make sure to check with an attorney who's licensed to practice in your state. Another critical component of an estate plan are powers of attorney. A power of attorney gives another person legal authorization to act on your behalf for medical and financial matters during your lifetime. This person is designated as your agent, sometimes called an attorney in fact, but they are authorized to make decisions about finances, healthcare, and other important matters if you become incapacitated or are otherwise unable to make decisions for yourself. Powers of attorney can also be used for convenience if you're not able or it's not easy for you to get to the bank or to write checks, making deposits, withdrawals, and so forth. But those are all details that you should discuss in the estate planning context. Another important piece of a power of attorney is that it may be the best way to avoid a costly guardianship process. If you don't have a power of attorney in place and you become incapacitated and need someone to step in and make decisions for you, if you don't have the power of attorney, someone's going to have to petition the court and request that a guardian or a conservator, sometimes it's called a conservator, is appointed to step in and help you manage your affairs. That process can be lengthy, it can be costly. So a power of attorney is a good way to avoid that from happening. Another important document that often comes up in the context of estate planning is a living will. A living will is also called an Advance Medical Directive. It outlines your wishes concerning medical treatment if you would become permanently unconscious or in a terminal condition when medical treatment would not bring you back to a quality of life but would only prolong the process of dying. The intent of a living will is to clearly establish whether you would want life-sustaining medical treatment, including things like cardiac resuscitation and invasive diagnostic testing, among others. Again, this is a basic overview. You can get a lot more detailed in a living will. You can really use the document in different ways to communicate to your loved ones how you would want them to make decisions or how you've thought about the document and how it should work under certain conditions. And so this is just a basic overview. And the last document that we'll talk about is a trust. There are so many different types of trusts, and trust law can get kind of complicated. So I'm just going to give a very basic overview, but just know that there are important considerations in the estate planning context where a trust might solve for a particular problem that you may have or your family may have. So the general idea behind a trust is that it forms a legal relationship where one person, who's often called the grantor or settlor, grants another person, who's called the trustee, the right to hold assets for the benefit of the beneficiaries who are named in the trusts. As I said, these trusts can be used for many different purposes. Certain types of trusts can be used for federal estate and gift tax planning, or for transferring assets to individuals who have difficulty managing the assets responsibly on their own. So for example, this can include beneficiaries like minor children, special needs beneficiaries, or individuals with addiction or mental illness. One of the most common forms of trust that come up in the estate planning context more broadly, so outside of the confines of Pennsylvania law, are revocable living trusts. I have a lot of content out there that discusses why, under Pennsylvania law, revocable living trusts are not as common. They are not a common or standard estate planning tool. They can be used even for Pennsylvania residents, but it's not a document that most people are having formed when they're going through the estate planning context. So if you're interested in learning more about why that is, check out some of the other videos that I've recorded and published on revocable living trusts. A properly devised estate plan is the best way to avoid doubt, uncertainty, confusion, and turmoil in the event that you would become incapacitated or upon your death. It can go a very long way to set up your chosen fiduciaries, the people that you want to step in and manage things for you, in a way that's giving them the highest possible chance of success and taking on that role in a way that's productive and efficient and isn't such a burden. So I really am passionate about encouraging my audience to get out there in their communities and their families, among their loved ones and friends, and start the conversation surrounding death and dying, because I know what happens when these planning strategies are not incorporated, and it's devastating. It can be devastating. And so I hope that you find this content helpful. I hope that this is kind of the starting point for your estate planning journey. I hope you'll find that it isn't that difficult once you get the process started. And I hope that you just generally found this content helpful. If you do like this content, please let me know, and I'll look forward to seeing you in the next video.